come stand here between these cameras.
Yep.
Thank you.
We're on?
Yes, it's on.
Okay. Testing. Y'all available?
We are plaintiff's counsel, and this is one of our plaintiffs, the lead plaintiff, Reverend Darcy Roque.
Okay.
So we're open to questions if you like.
Sure.
You
Come step over so Alex can get you.
Oh, come on. Okay, we have everyone here. I would love to see it next to
Please, thank you. And this is Alana Odoms from the executive director of the ACLU of Louisiana. I'm Heather Weaver.
Hello?
This is John Youngwood. We're
Yes.
two of the
Yes.
attorneys from the case.
You guys are
Okay.
close.
Let me
Step.
bounce off the microphone, please.
Do you want us? Are you asking me to hold that?
Oh, no. He's just he's adjusting some things.
Okay.
You ready? Okay. All right. Could y'all start by giving us your first and last names and how they're spelled?
Sure. I'm Heather Weaver, Heatherweaver. I'm with ACLU National, and I'm one of the attorneys for the plaintiffs in this case.
Jonathan Youngwood, JONATHAN, YOUNG, I'm one of the attorneys for the plaintiffs.
And my name is Darcy Roque, DARCY ROAKE, and I, alongside my husband, am a plaintiff in this case. And I'm a Unitarian Universalist minister.
My name is Alana Odoms, ALANAH ODOMS. I'm the executive director of the ACLU of Louisiana.
Okay, so we'll start with you. Just the day's wrapped. Kind of, what's your first reaction?
Well, our clients were really pleased to have their day in court. We think we presented a strong case, and we're eager to see what happens from here.
What was your impression from the judge's questions, his response of how you responded to your argument?
Yeah, I mean, the judge was engaged in both sides of the arguments. Again, we think we presented a strong case, but we'll have to see what the judge thinks when the decision comes out.
And y'all's witness that spoke this morning, kind of tell me what was your reaction after hearing his his testimony and then the judge's response to that?
I think he did an excellent job of summarizing the work he did on this case, the scholarship he has a basic lifetime of doing, and he's a true expert on the history of this country, of religion, and how it intermixes with this country. And we're pleased he was able to testify, and pleased the judge was attentive to his testimony.
And in the cross-examination, there was some questions about the analysis and potentially it being, objective. Or what are kind of or subjective, What was your response to that?
Our response was everyone's entitled to cross-examine. We're pleased to see that the state did it, but we think our expert did an excellent job answering those questions.
What do you guys want to tell parents about how you guys are working for them in this case?
Well, why don't we let the parent that we're working on behalf of tell you, why this case is important to her and why she decided to join the case as a plaintiff.
Absolutely. As a member of an interfaith family, I'm Unitarian Universalist minister. My husband is Jewish. We have educated our children in religious education. They've gone to Unitarian Universalist religious education, and they have also gone to temple to Jewish religious education. So we feel that religious education is very important for us as parents to do, to help guide our children within a context of our home. That is incredibly important to us. It is also incredibly important to us that our children go to a public school where there's a diversity of beliefs and values. That is so important to us. And we do not believe in one particular religious belief within a school system. And we also believe we're really excited about the interplay of ideas in a public school system. That's why we send our children there. So that's why we want to make sure that those remain separated. Both are very important, and it's very important that they remain separate.
And I heard a number of times today, saying the law would actually do harm to children. Could you elaborate on that a little bit?
Absolutely. When I think about that, there are so many different questions that we have when we talk to our children within context. These are without context, and it's something that they see every day. Not only that, but that particular tradition, neither my husband nor I follow that particular role of the Ten Commandments. In addition, without context, there's a lot of questions that may be asked that teachers themselves may not be able to answer. So where does that line end? I think it matters what we see every day. It matters to me what my children see every day, and that is why I want that separation. That is for my husband and I to have discussions with them, not the school system.
The judge noted repeatedly that the size of the font on the display was very small and he couldn't even read it from where he was standing. Do you think that diminishes your argument?
Well, again,
No.
I don't think we'll get into any particular specific arguments, but overall, we were really think that we presented a strong case here today. And again, we'll have to see what the judge thinks when his decision comes out.
If the judge does not issue the injunction and the posters do go up by the deadline of January 1st, what would that mean for you or family?
I think that's a really difficult question to answer. I mean, they talked about it in the court right now, but I can't answer for the future. But it would be incredibly difficult, and there would be some decisions that not only myself, but other parents in the public school system would have to make, and I don't want to have to make that. And I also don't want other parents who are in this position to have to make those choices. So I hope it doesn't.
Okay, thank you all.
Thank you.
Yeah.
Yeah, sure.
Do you think that there's gonna be? I'm gonna answer that way. I'm not following weirdo. Do you think that there's gonna be more cases like this? I know that it was mentioned right at the end, the teacher versus land grant.
Yeah, there have been other
setting my
cases that are filed. I do think this opens up, I think, the issue for further litigation. But again, we won't know how those cases will proceed until the judge makes his ruling. But I will say this, the fundamental principles of the First Amendment are the core central tenets of our democracy. The First Amendment has and always will be the most fundamental protection that citizens have in terms of determining their own religious practices and their own religious beliefs. And we believe that that does not change and hasn't changed, not since 1980 when the Supreme Court last made its ruling on this very same point. And so we still feel very confident about the future of how the judge will rule in this particular case.
Thank you, Elena.
Thanks, guys. Thanks so much. Thanks everybody for hanging in all day. Really appreciate it. Hi. How are you?
Good to see you. Yeah.
Bye.
So, do you have questions? Or
She's going to say something real quick, and then y'all can ask whatever questions y'all want.
Yeah, no, I would just say it was a long day in court, but I think that our pleadings, our briefing, and the arguments today illustrated that there really is no case that is ripe for the judge to decide. There are no posters that have been posted yet. The poster, which the judge actually, we had an illustrative, he wanted to keep it. I think it's about 11.5 by 14, so it's about this big. There's a lot of information that goes on it, and even the judge acknowledged that from where he was sitting, you couldn't see the print. So this case really matters. Context matters. What the posters say, where they are posted, when they are posted, all of that matters for legal purposes as to whether or not the judge has a case to actually rule on. So we think it's premature and made those arguments today.
What did you think about the witness that the plaintiffs called up, basically saying that the Ten Commandments weren't founded on U.S. principles?
Well, we filed a motion to strike that testimony because we just don't think that he qualifies as an expert under the federal rules of evidence. He's a history professor. He's done what history professors do, but this case is really about the legal test for whether it violates the First Amendment or not, and I don't think that what he said had anything really relevant to that question for the judge.
But in the legislation as it went through the system, the lawmakers talked about how it's a historical document and that the history behind it meets that muster to be able to stay in the classroom.
Right.
So how do you kind of stand that up to what the historian was saying?
I'm not saying history's irrelevant to the case. I just don't think we need a historian to be an expert witness in this case. History is history. You will see, and you can see, if you look at some of these other cases that have been litigated on whether any kind of First Amendment case, but just about any constitutional case that goes up at the United States Supreme Court these days is a question of history and what the founders believed at the time. And so there will be reams of paper used for amicus briefs on that very topic and submitted to the courts on this issue. And so if the judge wanted to accept that as an amicus brief, I think that would be fine. As evidence, we think it's not fine. So it's really more of a legal question about the propriety of his testimony and how the judge should treat it. because there will be a lot of people who have opinions on what the history is and what the history shows. I would point out that Moses is on the top of the east frieze of the United States Supreme Court. Moses appears inside the Supreme Court and outside, I think, in 9 different places. So yes, that history is relevant. We think it's relevant too, but it's just not appropriate to be for there to be an expert witness on that point.
Y'all argued that House Bill 71 will, quote, never be enforced against the plaintiffs. If that's the case, why defend the lawsuit so vehemently?
I'm not sure exactly what you're quoting. The law goes into effect on January 1st. What we said is that there is no poster now. Nothing has been posted now, and this case is premature.
In the argument about the posters being rather small and the text being small, despite the law saying it needs to be readable, why even have the posters at all or pass this law and defend this law at all?
Legislative policy, and my job is to defend the laws that are passed by the legislature. So, I don't stand in judgment of the policies of the legislature. My job is to presume that they are constitutional and defend them. I don't have to agree with them. I don't have to like them, but I defend them. And this law, I believe, is constitutional, and we've illustrated in numerous ways that the law is constitutional. We've shown that in our briefs by creating a number of posters. Again, you don't have to like the posters. The point is you can make posters that comply with the Constitution.
And so after a long day in court, obviously you've been here since 9 this morning. What are your thoughts? The judge has until November 15th to decide. What are your thoughts on the full day?
I think he's very, very interested in the issue. He asked a lot of really detailed questions. At the end of the day, I still think it's going to be very hard for the plaintiffs to overcome the fact that the law has not been enforced yet, and that there are no posters up on any wall, and that this is a very context-specific inquiry. And so, even if he has to dismiss it now, someone may come back and file another lawsuit later, but at that point, it will be a context-specific challenge.
One of the questions that the judge had raised was there was only one expert witness, and why not have the state bring their own kind of counter witness? What was the thinking behind that?
Because we don't think that a historian's testimony is proper for expert testimony. And that's why we filed what's called a Daubert motion to strike the testimony. The judge can still invite amicus briefs. He can let anybody file a brief in this case that he wants to allow file that brief. And he can evaluate that brief any way he wants to. But this witness was being presented as an evidentiary expert. He obviously wasn't alive at the time that these things happened. His testimony was admittedly subjective. The conclusions that he drew from the research that he's done was admittedly subjective. There are other historians who don't agree with him. Our point is this is not proper for an expert witness. Let him file an amicus brief.
How come you guys didn't call your own historian or expert witness in that case?
Because it's not appropriate for expert testimony.
Are there other statues of lawmakers besides Moses in the Supreme Court?
Are there, I'm sorry.
Are there statues of other lawmakers besides Moses in the Supreme Court?
There are murals and friezes in the Supreme Court that have, a number of different people, I think, on them that are considered the first lawmakers. Yes.
Got time for 1 or 2 more.
And do you have an expectation after this case, whatever the outcome is, that this will eventually make its way to the Supreme Court?
I think that it could very well make its way to the Supreme Court. I don't know if it'll be this case. And it really depends, like I said, what posters are created, when they're posted, where they're posted, what they say. All of that is context specific, and that's what the Supreme Court has said in these cases, is that it's a very context factual inquiry. So until that happens, I really don't think we have a case. I mean, we have a case, we have a statute to defend. I don't think they have a case.
Last one. Anyone got one?
What's the next step? What are y'all going to be doing from here on out?
What's the deadline?
Wait for the judge to rule. He has no deadline. He has said he will try to rule by November 15th, but there is actually no deadline. I believe that there was an agreement among the parties not to post anything, they're not really obligated to post anything until January 1st anyway, but they entered into some stipulations that they wouldn't do anything until November 15th. Once that date passes, that stipulation is no longer in effect, so I think the judge will probably rule by then.
Thank you.
Good?
Thank you.
All right, thank you.